Давайте начинаем.
Let us start then. Ladies and gentlemen, I'm happy to greet you at our session. It is our last session in the forum, and our topic is joint venturing, how to make trans-border or cross-border partnership work. And first, I would like to introduce our speakers. I will start. The first one would be Oksana Balayan, who is a managing partner of Hogan Lovells legal firm.
On iz Kazahstana I on partner juridической фирмой Zayat Zolsky and Partners. Then we have Svetlana Gerbel, она вице-президент и директор по правовым вопросам по России и Центральной Азии. Она работает у фирмы Siemens. И у нас есть также Suren Gatsun.
We also have Suren Gortsunian, partner of Gumstrauf and Hauer. Елизавета Karyagin is a head of corporate and for Megaphone. And last but not the least, Alexei Malavatsky, Executive Vice President of holding company Sistema, and Yakov Niletov. And my name is Cornelia Topf, partner of Gleiss and Lutz. I'll continue in English if you're okay with that.
I will start with an overview of what we want to talk about and what we want to achieve today in our session. I have brought an overview with me about how many joint ventures actually there are in Russia, and this is really quite a lot. It's more than 20,000 companies in Russia with a foreign investment, and many of them exist already since ages, since the early 90s and even before that. I have read somewhere that the average duration of a joint venture is 7 years, but of course there are also lots of joint ventures that fail even before that period. When I prepared for this session, I read an interesting quote of an investor, which was a German investor, about investments into other jurisdictions, and he said, a foreign investment and a local firm, foreign investor and a local firm enter into a JV. What happens? The investor brings the money and the local firm brings the know-how. After 1 year, the joint venture is terminated and the investor has the know-how and the local firm has the money. There may be some truth in it, not all, and we've brought a couple of examples with us that proved that joint ventures in the end can be successful. But of course, there are many reasons for a joint venture to fail. We do not want to go into this detail at the beginning of our session, but we will come to this later on. And the targets of our roundtable will be to identify what are the typical issues of potential conflicts between the partners of a joint venture. How can we avoid conflicts beforehand? How can we solve them when they come up? How can we protect the partners' conflicting interests? And finally, is there a recipe of how to make a partnership work? And we will start with a brief introductory presentation about the cornerstones of corporate governance of a JV, which form the basis of a mutual cooperation. And I will hand over to my fellow speaker, Oksana.
Thank you, Cornelia. Вот Корнелия нас всех представила.
Cornelia have introduced ourselves. She hasn't introduced herself, though. She has very close ties with Russia, and she would know how joint ventures are structured. with the Russian participation. Cornelia works in Germany, but she has very close links, in connection with joint ventures in Russia. Thank you for bringing us together for such an interesting panel. We have both lawyers and legal workers who prepare documents to reflect all those provisions and rules of the game for a joint venture, trying to foresee certain problems and provide for the future successful cooperation in a joint venture. And we have representatives of business circles who had some input into the rules of the game and who follow these rules and are often unhappy with what the lawyers have put down for them. And today we'll hear very different opinions. We would like to start with corporate governance. It is one of the major elements which is part of the corporate agreement, in the joint venture agreement, in the charter documents, in whatever documents you have covering the relations between partners in a joint venture. We've put down a working formula, success formula, or love formula for the partners in a joint venture. Maybe the print is too fine, but what do you need to pay attention to when we are preparing project documents? What topics should be covered in the documents? Well, first of all, you have to see to establish a proper control system. What body is responsible for what, who takes decisions, and what are the bodies. Secondly, joint ventures would not always have 50-50 shareholders. They have minority and majority shareholders, and it is important to find the balance between the big and the small, and see how the minority shareholders are protected, and see what the majority element would be. Of course, it has to do with the bodies responsible for decisions, etc. The third element, we called it greeting the best team on board. How do you nominate, select the manager, the managing team, who's responsible for it? What are the rights of the shareholders, of the partners, in nomination, in selection of personnel, and approval? Another important element is an access to information generated by the company, and it is important not to overlook the proper description of this access to information. If we're treating it in the framework of Russian legislation, we know that shareholders do not have access to all bits of information. So you need to discuss and decide and create a tool to do it.
The last but not the least, quite important as well, it is to understand how this system works, what could possibly happen, and what are the situations that the system might stop working, and how to resolve the situation if there is a deadlock between the shareholders or in the board. So the English word used for it is deadlock. And I just wanted to give you a few of the trends that we have identified reading the documentation of our clients. Svetlana, Lisa, and Alexei, please correct me if it is so or not, whether the things are the same in the cooperation that you are planning or those that are working. We see a trend to adopt the best practices from the governance system that is dictated by the rules and regulation at the public sector, and the standard system of committees and different bodies is being included into the joint venture agreements where there's no public components or any commitments and obligations. On one hand, it is good. You don't have to think twice. You just try to see what your colleagues have done, and there's a lot of expertise in this area. And another trend is not only the experience of complex management structures, is not only the shareholders meeting, it's not only the board or executive bodies. Sometimes the board of directors are set up when they're not even needed, but the elements from the public sector, like the presence of the independent directors in the companies, in the entities where that kind of independent directors are not needed at all. And a great number of different committees are set up, and these committees might not be demanded by the Russian law, but they are instrumental in the functioning of the operations of the company. We are moving from the legal to commercial practices. It might be remuneration committee or commercial policies committee, and such committees work, and they streamline the proceedings of the company, because if there are some deadlocks or conflicts, then that kind of committees elevate the matters to a higher level, and then the decisions are taken, and it is possible to influence decision at the higher level. And another trend is that there is the sophisticated internal rules and procedures development, and quite the codes of conduct are developed, especially in the companies with Russian shareholders only. This is the Western established practices and cultures, but these are being adopted in Russia. Take public companies, the number of the documents, internal regulations is a lot. You can get to the website of any public company like Telecom, and the list is some 20 documents. But if they are there, if the lawyers have developed that kind of documents, it is easier for the joint venture to exist, because the rules are available that you should adhere to. And the subject of compliance, which is related to corruption offenses, is high on the agenda. We have been talking at length about the cross-border enforcement of laws, and that kind of laws and acts is part of our life, and the companies and corporations that operate in Russia, and even that kind of entities, in many cases, if there are shareholders from different jurisdictions, should comply with certain rules. These are the FCPA from the US, UK Bribery Act obviously from the UK. These rules are applied irrespective of what jurisdiction the corporation was set up. If one of the shareholders is from the US, then that kind of rules and regulations should be applied in the Russian jurisdictions. This what the rule are, and so when the governance system is set up, that kind of element should be taken into account. And the other thing, not only related to corruption, but it is related to the sanctions. Sanctions is part of our life, which was not the case at the time when the sanctions were imposed against Iran. Now it is just on top of us, and if one of the members of the board is a holder of the U.S. passport, then you should be vigilant and try to analyze how the sanctions status might affect you. Sometimes the persons cannot even get to one room to take a decision. So the internal rooms and the analysis on how the sanctions regime operates is very important. So due diligence not only of the possible partners should be done, but of the specific personalities. Another trend which we observe, it is quite nice and pleasant thing for many attendees of the forums, and we can see that the Russian law is one of the elements that is used to structure joint ventures. Previously, the Russian law might be applied only to, say, prepare two-page document, but right now complex joint ventures are incorporated in conformity with the Russian law. We have a few cases, and all the regulation is covered by the Russian law. I attended some of the previous sessions held over here, and some of the opinions was that the legislators do not work enough to promote Russian law for joint ventures. We know there is we are now more proactive to work with China, and sometimes there's no chance for the Chinese companies to use any other law, and the Chinese companies can use only Chinese law to make joint ventures. And I think we should do something similar. The public companies, state-owned companies, should be prescribed to use Russian law only, and it will be interesting to discuss it in the audience whether the Russian law should be mandatory, despite now it is not a law in Russia. However, the trend is there. In general trend is that we do onshorization, and to make the incorporation by Russian law. So the Russian law is evolving. We have civil law reforms and corporate law reforms, and it is an indication that we are setting up new instruments for the joint venture members to get the required degree of comfort. The German investors are sort of concerned that you have a single executive body. We can have two. What is the protection? What is the comfort? How could we avoid having one executive doing everything? And right now we can have double-bodied two directors, and that kind of practices are established. Or look at another element. It is non-proportional distribution of the profit. And right now, at the limited liability company, there's there might be a privilege share reserved, and indeed many companies might make use of it. One can have a certain share. The size of the share could be determined, but the size of the profit that this share will generate might be higher. And that kind of provisions could be made when the structuring of the company is done. And there are other provisions. It is just a cancellation of the round seal, and it is scrapping the formalities. On the whole, if we analyze the Russian law. We don't know whether it's a trend or not, whether it will be a long-term trend or not, and we can see that there are changes in the investment law as well, and hopefully the joint venture will have a long service life, and hopefully if something goes wrong, how could we exit from the joint venture? And the shareholders agreement is one of the instruments that allow the shareholders to do that. And in conclusion, I've presented the structure of it is minority and majority shares, and to structure the board correctly, and there could be different bodies. The flexibility is available. We can choose the format, the type, the kind of the legal person. We can see what bodies are necessary, but in any case we have a shareholders meeting. We have to identify who the CEO is, and if it's a single person, then how the who and how the appointment is made, how is the collective responsibility, is it by the board, and then the board is elected, and then the board appoints the CEO, and if the share is 70/30, there are 2 directors from majority shareholder and 1 director from the minority shareholder, and then 2 independent directors. And it is hard to achieve that kind of setup, but if you have independent directors, it provides the required comfort to the minority shareholders, and the minority shareholders could even achieve the majority at the level of the board of directors if they don't have it among the shareholders. And here are the other committees, and to the right you see the code of conduct. You shouldn't forget, you shouldn't overlook it, and the internal rules. It is not a checklist, of course, but it is something to bear in mind, not to forget about something. And the last thing that I would like to mention, Cornelia mentioned this funny case too. In legal profession, there's a joke which is when there is a crow on the tree doing nothing, idling, enjoying life in general, a rabbit running about and saying, could I just sit like that on the branch and do nothing? The rabbit is sitting doing nothing, and the fox charges forward and eats the rabbit, and you could sit tight and do nothing, but you should be high. And if you make all the right seeds, you would be sitting idling, and in most probability the fox would not eat you up.
Immediate questions from the auditorium? That's not the case, so otherwise I have a first question to Lisa now. Lisa, how does your firm approach a new joint venture? Do you have a blueprint or a template for joint ventures that you usually use, or how does it work?
Безусловно, у всех юристов.
Of course, all the lawyers have got templates, the model contracts, and all the lawyers that handle joint ventures have got the set up of standard positions, and we should make provisions for that. But on the other hand, joint ventures are unique, and much depends on what the purpose of the joint vehicle, and to fine-tune the templates, otherwise it won't work.
Lawyers always tend to make things overcomplicated, and I've seen many joint venture structures where the structure really was very, very sophisticated, with lots of committees here and there, and mechanics of how disputes will be solved and how CEOs will be nominated at what level. Alexei, my question to you, have you ever made any experience with a joint venture where the corporate governance was over-engineered and didn't work in practice at all?
indeed, we have faced the situation when, with the help of the lawyers or internally, the corporate structure, the corporate governance structure was so much complicated that it didn't work. And then it was necessary to introduce adjustment into all the documentations, taking into account the specificity of the joint venture. I agree with Lisa on the unique approach to unique joint ventures, and that's why the corporate governance structure should take the specificity into account. In our system, and we face different joint ventures, and it might be small or large. Small joint ventures are the joint ventures with the shares of some 5 and 7%, and sometimes the share is up to 99%. We do have cases like that. So it's all individual, and we should indeed see what is the specific case.
Søren, how do you find out in the first place which corporate governance fits your client's interests best?
Ну, разумеется, в первую очередь ты анализируешь позицию.
First of all, we analyze the position of the partner of the joint venture. If the partner is supposed to be the majority partner, then the set of their rights, the possibilities of influence should be more, and the structure of the governance should enable the partner to do so. And if the structure is 50 by 50, that's the subject matter of our discussion, is much more complicated, and the set of rules is more limited, but on the other hand it is more elaborated. Much depends on the tasks and the purposes of the clients and the context of the particular entity.
I would like to come back to one of the points that Oksana mentioned, and she said one of the rules is greeting the best team on board. And this is a question to Svetlana. Svetlana, what is the best team on board for Siemens?
Я тоже согласна с тем, что сказала Оксана.
I agree absolutely to what Oksana said, and it is necessary for the team to pursue to achieve the goals that both partners have set for themselves. And there shouldn't be a tug of war between the partners. Of course, it's not an easy matter to build up a team like that. I represent the interests of the foreign partner, and I see the situation that after the joint venture, the foreigners believe that, okay, here we are a partnership, and we should oblige, we should move our part of the road, and the Russians set very strict requirements, and the foreign investors oblige. And I think it is important for the CEO, CFO, remember the tasks, the purposes of the joint venture, and they should protect the interests of their shareholders. So I think the team should meet and protect the interests of all partners.
Do you usually use independent board members, or would you rather go for a so-called group officer, so that you know that the person on board really represents your interests?
Нет, у нас нет независимых директоров.
No, we do not have independent directors, but we have the so-called integration managers. These are the people who are aware of the mentality of one partner, both Russian partners, and undertake, if there is a deadlock, to resolve the dispute, explaining to both parties why the conflicts, trying to act as a mediator, because Russian partners fail to understand the rules adopted in Europe, or why that kind of requirements are made by the Western partners, like the requirement of compliance. And it is necessary to explain why the compliance principle, why it is necessary to adopt the code of conduct. Some of the partners do not understand it, and to have the same understanding level of comprehension, the integration manager is there. It could be either Russian or German or English. It just depends on the competencies and expertise of the specific person and whether the person could be helpful or not.
When it is about money, the friendship ends. In this sense, I want to hand over the power to Alexei, because one of the critical items in a joint venture where a dispute can arise is financing.
Добрый день еще раз, коллеги.
Good afternoon, distinguished participants. Thank you for coming here. I would like to discuss today main financial issues that may become a bone of contention, that may lead to deal breaking or end up the partners in an arbitration court. So these issues I'm going to dwell on are extremely important, are essential to keep in mind. They should be in focus in your negotiations with partners from the very beginning. You have to settle things right from the start. It is a bad practice and a bad habit to postpone their solution till the time when they arise. Generally speaking, the philosophy of any joint venture is based on two things: combining financial resources of two partners and sharing of the results of economic activity. This sharing may be either in the form of positive distribution, profit sharing, dividend sharing, or negative distribution, that is sharing losses. Any joint venture may be subject to failure. According to my statistics, during the period of last 3 to 4 years, over 70% of all joint ventures end up failure. This is a rule. Every year, despite the risk of high risk of failure, more and more joint ventures crop up. More and more of them try to test their luck in the treacherous waters of business. Any project, any joint venture is an expensive project to begin with. It requires expenses of time, services, and usually they are all pretty risky. Despite the amount of money you invest, there's always a risk of losing them. Despite how much effort you invest, there's always a risk of failure. Therefore, before you decide to go into it, you have to make an evaluation of your decision through the prism of financial decisions. First of all, you have to understand the financial architecture of the coming joint venture. What is at stake behind the transaction? Then you have to have a clear idea of what is the intended success. What elements go into building your success, financial success. And a third thing to keep in mind is the financial needs of the joint venture itself. One of those elements is usually overlooked. And when it's the case, it is almost always a recipe for disaster and eventual death of the joint venture. Sooner or later, conflict will arise. Therefore, to avoid a conflict, you have to come to terms from early on. Every single financial issue has to be settled early on, before the joint venture is effective. Let me tell you about the lessons learned in my career. Well, first of all, it's the contention over the amount of contribution or shares. Then comes business plan and budget planning. Who is going to plan the budget? Who is going to approve the budget? How will the joint venture survive once a budget has not been approved? And joint financing of operations of a venture. Usually those things are considered marginal. However, once they arise, everyone understands that those were the issues of survival. Another issue to be kept in mind, a very essential and tricky issue, is additional financing of the joint venture. Additional financing may lead to a dissolution of weakening of a share of one of the partners. We will come to that later on. Next thing is the distribution of income. When we talk about sharing, we share not only profits, but we share always losses and liabilities. And the joint ventures often score losses. And finally, taxation. Taxation is usually a technical issue. It is not a legal issue. It is a matter to be settled by tax lawyers and tax consultancies. Now let's have a look at a list of issues connected with the contribution. Contribution is the beginning of any discussion between the partners. The issue is very serious indeed, because the contribution will be the foundation of the entire thing. Contributions create expectations. Contributions create rights. Contributions were the thing behind the partners coming together. In reality, we see that joint ventures do get established without prior financial evaluation. Partners just stake a sum and think they're there. I think this is a fundamentally erroneous practice. You just cannot go arbitrarily calculating your contribution. The next thing you will come up with is a conflict over your contributions. It turns out that having contributed an amount, a partner had more expectations than he actually had. My recommendation is to make an independent assessment of the financial needs and financial distribution in a joint venture, and that evaluation should be based on evidence and analysis rather than feelings and expectations. Financial contributions may be in assets, real estate, intellectual contribution, brands and the like, patents, and a promise of a service. Each of these elements has its own features. However, the third final contribution of a promise of services is very difficult to put a figure on. Expectations and calculation of a service rendered will vary depending on circumstances. That would inevitably lead to confusion. In reality, we face a situation when partners somewhere along the road would adjust their contribution. In a period of several months, partners come back together and discuss their contribution considering new realities. Either they adjust the prices, or they adjust their assessments or their proportions or whatever. An extremely important issue is synergy. 90% of cases, synergy is #1 priority in relations between partners. Most of the time, partners tend to overestimate, overextend their evaluation of synergy. This is something to keep in mind. Don't jump to conclusions, don't have inflated expectations. And the final thing is contribution in IT technologies and IT skills. Again, it is something that is very difficult to quantify. It is extremely difficult to put a price on a brand, on a trademark, on experience or skills. This is extremely capital intensive or time intensive, including registration, applications, all of those procedural things. They can also be extremely expensive. So be careful when you are proposed a contribution in intellectual property. Now, when those stages have been passed, partners would begin thinking about the budget. Every partner will have his idea of a budget. There would be partners who would see their participation in joint venture in a limited or a restricted format. He would participate in building a site and then opting out. Another partner would see his future as a long-term user of the facility. So depending on their individual visions, they would influence the budget. This means, in practical terms, that you have to come to terms together with your partner about the vision of a budget. Business plan is basically the same thing. A business plan should be and is usually signed prior to the establishment of a joint venture. Its lifetime is about 5 years. Initially, it is called a draft business plan that is subject to adjustment after a certain period of time, the so-called midterm review. Now a question begs itself: what happens when the midterm review fails, when partners fail to come to terms over their adjustments? One possibility is to use the services of a third party, of a mediator, usually a legal counsel from a legal consultancy. Usually adjustments relate to inflation or tariffs. This is a simple case. In more difficult cases, partners would invite a third person. Another thing to be conscious of is decision-making rights over the budget. A business plan should be managed by the majority stakeholder. Minority stakeholders would have motivation to jump into the process and try to claim a stake in it. Now, the issues related to initial capital. Usually this issue is underestimated, is ignored. Once everything has been settled, parties suddenly realize that they have some pending issues related to initial capital. Therefore, it is very important from the very beginning, from the very start, to calculate your contribution to the capital fund. The basic principle here is that all contributions should be carried by the party who is financing the contribution. For instance, contributing with intellectual property. It is a very expensive thing. Therefore, sharing of expenses and benefits would be proportional to that, to the proportion of the contribution. Additional financing, as I've mentioned, it carries the risk of dilution of stock. Usually, partners try to come up with a financial model that would account for every eventuality. It is a hopeless proposition. You can never anticipate every risk there is out there. What happens once a partner fails to pay its contribution to the capital fund? What happens with the joint venture? Now, one thing we have to be clear about is that minority stakeholders cannot be allowed to drag business. If a minority stakeholder fails to make a contribution, then there should be some mechanisms in place to compensate for that. Either leverage his contribution, or fine him, or make an adjustment, or whatever, or simply take over his contribution. We do know 5 or 6 ways to dilute your part in the capital fund. Please be careful about this and mindful about this from the very beginning, before you even contemplate establishing a joint venture. Don't allow a possibility of a deadlock. It is a very bad habit to allow situations to develop into a deadlock. Nobody knows what to do. The financial activity is effectively stalled. To avoid such kind of eventualities, you have to stipulate it in every detail in your agreement.
The next issue is distribution of revenue. There's always a conflict of interest. What do we do with it? Do we reinvest it, or do we take it? The joint venture should better foresee the future situation. If we have revenues and there's no demand from the creditors, 90–80% is allocated to the shareholders, depending on the shareholders' agreement. Who makes decisions when deciding about distribution? This should be left to the majority shareholder. In certain cases, minority shareholder would also have this right, but it only refers to projects, to specific projects where a minority shareholder deals with the project directly, and they contribute into the project with their intellectual property. And the last bullet on this slide, sometimes the venue, the facility would generate losses, and parties either have to pay or to close down the company. Well, here we need to see the threshold. Up to a certain point, the parties should make capital investment into the joint ventures to cover the losses, to save the company from liquidation or bankruptcy. The last slide has to do with tax considerations in regards to the whole structure of the joint venture. And here maybe there are 3 points to think about. The first is jurisdiction. We are talking a lot about de-offshoreization, and we have accepted this term. Everybody tries to go from Cyprus to Malta, for example. So here you have to calculate at every level how much will you have to spend in case you will have to sell the project or sell the shares in the project. Depending on a jurisdiction, tax issues may influence your financial outcome. Sometimes parties, for example, choose Cyprus as their jurisdiction, enter a real estate project and find out that you have to give back 12% once in capital gains when you sell a project. So you have to be careful about various matters, taking into account de-offshoreization. And the companies should, before the 15th of June, all companies have to make sure. The next question is, what do we create, a company or a partnership? If you create a partnership, you participate not only in the revenues but also in the costs. And it's a default provision, and you always have to look out for it. How do you fund it? It's either loans or equity. It's also a tax question, a tax issue. I think equity is a better choice. And additional funding can be provided through loans. It's better from the taxes point of view. And when we talk about profit distribution, dividends, it's either dividends or interest loan repayments that shareholders provide. Each jurisdiction would have its own tax regime, and it has to be weighed and calculated beforehand. To sum it up, I would say that financing issues should be foreseen beforehand and not to be left out until deadlock. Everything should be written down and provided for, and you should be open with your partner, because sometimes partners would hide something, would think that sometimes people are in the hurry. They would say, well, my asset price is this or that, and they understand that in a month they will have to open their asset prices, and later you find out, when you do the balance, you'll see that the financial results are bad, and in a month you reach a deadlock because you understand that one party has cheated on the other. Maybe this is all I wanted to say, and I'll give the floor to our moderator. Thank you.
We move on to deadlocks in a second, but I wanted to touch 2 points again. One is the business plan. We all know that the management cannot run a joint venture company without an approved business plan, and a business plan can be a controversial issue, of course, because usually you would have kind of a provision in the JVA which says that all actions that are included in the business plan do not need any additional approval by the minority shareholder. And that's why I wanted to ask Oksana, what kind of provision would you recommend to your clients to include in the JVA to make sure that even if the business plan has not been approved, the joint venture can be continued?
Thank you, Cornelia. Well, I think my position, frankly, is that it's very difficult for the minority shareholder to negotiate the right provision in the shareholder agreement or in the joint venture agreement. So, whenever possible, my recommendation would be to have the business plan approved or agreed, to have it in the agreed form for as long period as you can with specific items at the outset, so that at least for the initial period of functioning of the company, you would have a possibility to get certain items through the corporate bodies without without any rejection. So that is critical. Also, if you look at the Russian reality now, for example, in certain joint ventures, no matter what provision you would have, the minority shareholder will not even be able to influence the business planning. For example, Russia very recently introduced restrictions for media companies, for foreign companies, media companies, to own more than 20% in Russian media assets. It's not only prohibition of ownership, it's also prohibition of any form of control over the joint venture. It means that if, for example, you agree that a specific provision in the joint venture agreement that would allow you to have certain input into the business plan, this could be interpreted as economic control or financial control over the company. This means that, again, contractual protection would not necessarily help you, and you need to make sure that the business plan is in existence upfront. Of course, joint ventures are not created for 1 year, for 2 years, or for 3 years. It's something which is created for long. And I think that here, the minority shareholder, without having, being in the right jurisdictions with the right organs, would always have a difficulty with the input into the budgeting, into the business planning.
Aman, do you have anything to add from a Kazakh perspective? I'll give you some time to think about it and ask Zirin if he has anything to add.
Well, if you want to hear the answer to your specific question, in many joint ventures, partners have reached an agreement, for example, from experience, that in cases where the parties are not able to agree on the business plan, then the business plan for the preceding year continues to create sort of pressure that unless they agree, then the joint venture essentially will stall. But that's probably not an ideal solution, but I agree with Oksana, for minority shareholders, it's probably the best situation where they can negotiate, because the veto rights that Alexei mentioned are rarely given to shareholders who own less than 25%, in my experience.
In situation when we do not have made our plans which we put it in our JV agreement, I think that in any event we need to have goodwill, wish from the parties to solve this situation, and it is the key issue. In case we will not have this wish from the parties, we will not be able to find the solution.
Okay, we'll come to this point in a second. Then one last question regarding dilution, and this is can be one of the results, of course, if the financing is not provided pro rata by the shareholders, as Alexei mentioned. Lisa, have you and has your firm ever diluted another partner? And if so, has this been a very smooth process, or what are your takeaways?
Well, I had the experience of dilution in other company, not in Megaphone, before. And this is a difficult question because actually the minority partner who is diluted actually has the same value because someone else contribute the money, so the equity which this minority partner holds actually is less in percentage, but probably it's the same in monetary value. Well, process like that is always painful and not easy. And it can actually, well, in my case, it took about a year, and it ended up in buying out this minority shareholder in a price which probably he would never get in the arm's length transaction.
Then my last question is to Svetlana. Svetlana, has Siemens in Russia ever been diluted?
No. No.
We stay with you for another while, and I would like to hand over the power to you. And we now move on with Deadlock and with a very interesting case study.
Многие юристы считают, что
Many lawyers would think that a joint venture is like a family. Tolstoy used to say that all happy families are alike, but all unhappy families have different issues. Well, Siemens has an interesting experience in this regards. At present, we have 9 joint ventures, only in Russia only, and every year we have new joint ventures and created, and previous joint ventures are being liquidated. Well, I don't know how many years, how many joint ventures Siemens had over 160 years, so we have a huge experience. And I can also note that each venture, if it is being liquidated, the problems are different, they're unique. Deadlock is a situation, a dead end, when partners cannot a deadlock means that the partners have a conflict, enter into conflict, and cannot resolve it. Well, the charter and agreement are of no help, and the question is what's to be done. I can tell you about. I can describe a case. I won't name the partner or the company. It's a very interesting case, and I think it is a good example to understand how you can get out of a deadlock. We had a joint venture, 51% to 49%. Siemens contributed with technology, with equipment, and provided funding on the stage of creation of the joint venture. Our partner contributed with a building, with a facility. The facility was built on a land plot which belonged to our partner. Siemens provided technology, know-hows, equipment, trained engineers, but unfortunately our partner did build the facility for the production line, for the joint venture production line, but the equity was not contributed. There was no contribution of equity. The construction took longer time. Our partner encountered some financial problems because they took a big loan, and they demanded us, I mean, that the joint venture would sign a rent agreement. So they did not hand over the facility. Instead, we had to rent this facility at a market price. We agreed to the deal, but very soon our partner demanded to rise the rent by 5 times, and this was the moment when we entered a conflict. They needed additional funding because it took too long to build this production line. Very often parties would not calculate beforehand what would happen, and they don't realize that it will take a longer time. So the parties, when they think they will have a return, let's say in a year, on the investment, but they only get their return in 5. We miscalculated the return on the investment. They wanted more money. We were not ready to help them, to assist them. There was a deadlock. Our partner filed a case to the court. They wanted eviction. We, on our behalf, filed a case to exclude them from the joint venture. We built up this agreement under Russian legislation, but we had it signed under Swiss legislation. We could go to Stockholm for arbitration, but a lot has changed over time. And when we estimated pros and cons, we realized that this decision would not be properly enacted in Russian Federation. Once we filed a case to exclude our partner from the joint venture agreement, they did it themselves. I mean, they walked out on their own. I used to work with conflict resolution a lot, and courts are not always a solution. They help you to make your position stronger during negotiations. We exchanged claims, we would arrest assets, but we kept negotiating. And I think that deadlock, the only solution in a deadlock is to keep negotiating. Of course, you have to strengthen your position. You need to try and strengthen your position. You need to take measures to free yourself from pressure. But in my opinion, after 20 years in consulting and working for Siemens, I think it's most important to find people who are able to negotiate, who are able to find some mutual points and seek compromise. The case with this partner was very complex. There were 4 trials. We had to go to government agencies and bodies. The partner had support in the region. For example, in this case, this partner was strong. He could lobby. They could lobby their interests. We are a foreign investor. We have fewer chances in Russian courts. In such cases, what you need, well, you need different tools, but you shouldn't keep silent. You should go to governmental bodies. You should draw politicians' attention to the case. You should go to embassies, to consulates. We went to the federal ombudsman, who was of help. It is sometimes useful to talk to a governor and say, well, we have invested in your region, and we don't see support. We have problems with bailiffs, for example, and if we don't resolve it somehow, or resolve it in a fair way, if we don't feel it, we'll just leave the region. This is exactly what happened in our case. We dismantled the production line. Part of it is arrested. We're going to produce this equipment in a different region now. But I know that not every investor is capable of such action, because to relocate your production is very costly. But since we've been on the Russian market for over 100 years and we're not going to leave, we know we're here for a long time. So if we have decided to invest and localize, we're going to do this. If it doesn't work in this region, we'll go to another region.
Lesson.
And the last, lessons learned. What should be taken into account? If there is a deadlock, one should look what's behind the back of the partner, who the beneficiaries are, and you should find common grounds with the realistic beneficiaries. You should talk with them, you should communicate with them, you should draw attention of the state to the matter if the partners position is no good and if they try to pressure you. And I think when it's a joint venture, you should not put yourself into the situation when the partner provides a real estate. When you rent the structure, the building of your partner, you have a weak spot, and that's what we faced in our practice. It is much better if the joint venture would either rent or buy a property as such. We do have both onshore and offshore companies, and if it is the offshore companies in the Netherlands or in Switzerland, we didn't have that kind of problems over there, like the case I'm talking about, because in 90% of the risks mitigated when it's a different jurisdiction. And when joint venture is set up, you should understand how strong is the position of your partner in the specific region that you are investing in. That's about it. Thank you.
If you knew beforehand how this dispute about making contributions ended, I know it's a tricky question, but is there anything that you have provided differently in the joint venture agreement beforehand?
Скорее всего, нет, потому что достаточно хорошо было.
We had all the required regulation, and what I could possibly change is I would rather make a team that will be dealing not only with the discussion, the agreement and drafting the documents, shareholders agreement, but we would be responsible for the implementation, because it is important to follow up what the parties are doing to implement the agreements, and that's what is being overlooked, because the documents are signed and they are put on the back burner, and there's a new team that is invited to do the production, to run operations, and there are no people that are from the initial idea up to the end of the life service. The situation is alive and it is changing, and so it's necessary to modify the documents as well, to adapt the documents for the situation. That's what I could change.
Presentation that Siemens indeed has had stipulated mechanics in the contract of how to solve a deadlock, including an escalation mechanism. And I'm now wondering, how useful is it actually to have such kind of escalation mechanism in your JVA if it doesn't work in the end? So, Alexei, do you have any view on this?
Я, во-первых, сторонник не оставлять открытым.
And I am the champion of not putting the deadlocks on cold burner, because if there are a framework for the deadlock resolution, it is the motivation to resolve the situation in the future. And despite all the complexity of the issue of the deadlock, when the negotiations are, it should be resolved, and the machinery, the framework should be inbuilt into the incorporation documents, and there shouldn't be any uncertainties. We shouldn't have ad hoc situations when the two parties just to say, okay, when it's time to resolve it, we will think how to deal with it. This is a wrong approach, and it is as a result, the business stops, and the two parties start greenmailing and blackmail one another, and the dispute will have to be taken to the arbitration, to the court of arbitration. And my opinion how to structure the deadlock, there should be a two-level format. First, it is to try to address the issue at the level of the management. There should be time 2 or 3 weeks, and some experts say 6 months for the deadlock. No, it's no good. If they cannot resolve if the management cannot resolve the issue within 2 weeks, they won't be able to resolve it after 6 weeks. Another level is the shareholders, and if the shareholders fail to resolve the situation, then it means there's a lack of trust between the shareholders. And if the shareholders cannot do that, then all the deadlock framework and machinery should be applied like the pay off by the majority, because the valuation issues will have to be taken into account. But anyway, it should be included, and all the rules on deadlock should be documented. The 5-6 pages should be prepared. There are good recipes how to deal with deadlocks.
Does a deadlock always mean the end of the joint venture, or what are your experiences?
Well, I have seen several deadlocks which were successfully resolved, but unfortunately, I mean, of course, ultimately, as Alexei said, that I mean, if none of the deadlock resolution options worked, then the best option perhaps is to litigate or arbitrate, depending on the circumstances. I think that usually, in my experience, if it was resolved by the escalation procedure that you mentioned, then this is the sort of usual situation where the things end up peacefully. Situation where management involves shareholders is 50-50. Sometimes it ends up in court or arbitration, and sometimes it ends up amicably. But that's just my experience with this.
We come to the very interesting 50-50 scenario at the end of our session, so it's worth staying with us. And I would like to raise another question to Lisa. So what are your experiences with deadlocks?
Well, I was planning to talk more about that during my presentation. I completely agree with Alexei. It's very important to have everything described in the documents, especially if you have a minority and majority shareholder. But, well, my personal view is that if you have the 50-50 joint venture, about which I'm going to tell, probably the best way is not to have any deadlock scenarios, because usually the situations ends up in mitigation and negotiations anyway. And if the parties can't agree even on the highest level, there is only one way: one partner should quit. So deadlocks probably will create more grounds for greenmailing than solutions.
And another question is, if you solve it by litigation, then the question is, can there ever be peace again within a joint venture and litigation case? And in this sense, I wanted to hand over to Aman. He comes from Kazakhstan, and I would like to know more about investment protection and minority protection under Kazakh joint ventures.
Спасибо большое, Корнелия. И снова здравствуйте, коллеги. Большое спасибо.
And once again, thank you, colleagues, and I would like to thank you for staying with us, for having the stamina to do that. We appreciate it highly. Listening to my colleagues, I've come to the conclusion that we have a joint vision how the joint venture should proceed, and they say that if there is a joint will, there is a way. That's kind of saying, and only in this way the joint venture would be efficient. If one partner is not willing and failing in performance or having some kind of disputes later on, then the question arises whether there is any point in continuing. But that doesn't mean that everything should be left to the devices of the shareholders or discretion of their partners and try to resolve the conflicts when they arise. Of course, the groundwork, the preparatory work should be done. And it is quite interesting how to describe the rights of the minorities, minority shareholders. Of course, if there's less input, financial, then the minority shareholders have less rights. But the minority shareholders are needed, and we should think on how to protect their rights as well, to give them comfort. Let me tell you how we protect the rights of the minority shareholders in Kazakhstan. I would like to present one case that it's a joint venture, 76 share of majority shareholders with 24. Both investors are foreigners, but they still operate in Kazakhstan in compliance with the law of Kazakhstan. It is related to the use of mineral resources. And the parties described the instruments to protect the minority interests, and there was a provision adopted for qualified majority, and it is related to the reserved matters, and there was a framework of sanctioning, and that's why it is in bold at the slide. It is sanctioning major transactions. And we don't have such a notion of sanctioning, and because first it is there should be a transaction and then you sanction it. It's not the preliminary agreement on striking a deal. And the supervisory board was included, and there was an arbitration clause in the shareholders agreement. So what's the dispute is about? The company worked for some 2 years generating profit, and so they've been taking decision that okay, let's sit tight without distributing the money, and there was an agreement regarding that, but then the minority shareholder realized that the chief executive is making deals to provide loans to affiliated companies of the majorities, and the information of the affiliation was available because the majority shareholder is a public company, and the matter is raised at the shareholders meeting to sanction, but the transaction is there, and because there are certain legal obligations, and the minority shareholder is wondering, of course, why should we loan, why should we give the money away? And then they started to study that lending transaction, like the money is presented in hard currency, and all the services are paid for in domestic currency, and the company undertakes all the currency exchange rate. And allegedly this particular bank was had a security by the warranty, by the pledge, but it is the pledge from the company that does not operate in Kazakhstan jurisdiction. So this security is not liquid. So when the documents were handed over to be analyzed by an independent auditor, so the point is that the remuneration for this deal was 4%, and at the internal market, the profit of this, the amount of money is actually all the profit for the previous 2 years. It's big money. So it was the loan for the interest of 4%, and that the local market and the blanket loan could not be received at all. So it was just a golden parachute for the other party. And so we have analyzed the situation. We have been talking with the academia, and in fact, the point of view was, well, the minority shareholders should be thinking well in advance about protecting their rights, because you said here is the qualified majority, there is an authority of the majority shareholder, then the majority shareholder has vested rights to do that. So when we analyzed the possibility of protecting our client, the minority shareholder, in this situation, we realized that there was a disbalance of power, and the methods of protection should be retrospective and prospective. We could have done some proactive measures, like consider whether this particular transaction was advisable to make or not, and then as reactive measures or post-transaction activity is claiming damages or bringing officers, holding officers liable. But our client realized that that kind of actions will paralyze the activity of the company, because the company will not be proceeding with the investment program, and it will be suspended, discontinued, because of the conflict between the shareholders. And a decision was taken to find common grounds, and I think the two parties have come to an agreement. And the conclusion that we have drawn for ourselves, lessons learned, is when the shareholders' agreements are developed, the retrospective methods of protection should not be the only available means, because some of the partners could abuse their rights, their authority, and they can risk the conduct of business, and it will be one of the one of the points, one of the reasoning in argumentation. So I've been attending the different sessions at the forum, and the other option is less realistic, because Kazakhstan have got certain specificity as far as legal system is concerned. Let me explain. Indeed, we have the clause with respect to the shareholders' agreement, and just like in Russia, the shareholders' agreement should not damage the rights which are covered by law, like it is related to the a right to nominate candidates into the board, and the right to draw dividends. There's a high concentration of capital, of wealth in Kazakhstan, and virtually every joint venture shares are split into majority package, and There are a few cases of 50 by 50 joint ventures, but it is rather an exception than a rule. And there's no exchange market, unfortunately, in Kazakhstan. Why unfortunately? Because the operation with shares is only 1% of all the scope of the exchange market, and it is a pathetic figure which is not acceptable for the market economy, and we should do something about it. Another point to raise, there are no green mailers in Kazakhstan, and it is too bad. And it might sound strange for you, because there might be somebody who has been fighting green mailers, but I believe that green mailers is a certain indicator that there is a developed economy in the country, and there is a certain degree of protection of the minority rights. It's just like a pack of wolves for the rams, so that the rams should be agile.
We usually have a passive core of minority stakeholders. Our practice is the domination of majority stakeholders. There may be cases and opportunities for a minority stakeholder to claim against a majority stakeholder or to protect his interest in court, but this is a rare occurrence. Another example from our precedents. We have a joint stock company with one majority stakeholder and half a dozen minority stakeholders. One of them had his doubts about the behavior of the majority stakeholder. Doubts about the fact that trade partners have some intimate connection with majority stakeholders. There was a feeling that part of profit was leaking away to individual persons affiliated with the majority stakeholders. So that particular minority stakeholder applied for private information on the activities of this particular joint venture. The joint venture, represented by the majority stakeholder, protested pretty violently, and pushed a decision in the board that this kind of information be protected by confidentiality. This is a prerogative of the Board of Governors in our law. So decision was taken, the articles were amended to include this expanded version of confidentiality. Now, of course, minority protested, filed a suit in court. The First Circuit Court supported the minority stakeholder. But that was not the end of the story. The Second Circuit Court reviewed the case and left the case effective only partially. However, the Third Circuit Court completely eliminated, nullified the initial decision, whereby the minority stakeholders completely lost his case, and with all the ensuing costs. Speaking about recommendations about protecting minority rights, stockholder rights, we as legal professionals have to ask a question: whose side are we on? Even if we are on the side of the majority stakeholder, and even if we act within Kazakhstan jurisdiction, I don't think there's a risk of excessive protection of minority rights. Minority right holders usually comply with the dominant position of the majority stakeholder. They do not eagerly go to court in view of high costs involved. Of course, the situation may be different in the Russian jurisdiction. It is important to analyze a set of instruments for a joint venture, to use a reactive or proactive set of instruments. As we speak, Kazakhstan is going through a number of reforms. The EBRD is reforming its own rules on joint venture, and we're following suit. We have already signed an agreement with the Business Association of Kazakhstan, and every business, by the way, operating in Kazakhstan must be a member thereof, to undertake, to initiate a reformation of their economic relations. A couple of weeks ago, we have launched a major nationwide reforms, which is called 100 Steps Ahead. This mega reform will completely change investment landscape. German Gref, when having read this reform, he was profoundly shocked, to use his own words. The country is following suit of Dubai with the application of British law, with the use of the English language as the economic language. Total liberalization of income tax for physical persons. Nationwide regime of free trade zone. A visa-free regime, and all sorts of liberal measures. Among all the set of measures involved, there will be an investment ombudsman, an investment commissioner. Therefore, within a short period of time, 6 months to 12 months, the landscape will be completely different. Well, that would be a perfect topic to
question, Svetlana, when Siemens is in the minority, what kind of minimum scope of minority protection do you need?
Вы знаете, у нас чаще всего в зависимости от конкретной ситуации.
That depends on a specific situation. What is mandatory is compliance provisions. The joint venture to be established must mandatorily implement compliance provisions. These rules of governance, which include compliance provisions, it's just about the minimum that is mandated.
Is there any basic rule of what the maximum extent of minority protection is that you could give to a minority shareholder?
Мы занимаем всегда позицию, что пакет прав, который предоставляется либо минору, либо мажоритарному акционеру, он все-таки
The the measure of protection of minority or anybody's rights for that matter must be intimately linked with the contribution, with the share of contribution. I believe that protecting minority rights beyond the contribution that the minority stakeholder makes is simply nonsensical. There's a certain amount involved. There's a certain contribution that stakeholders make, and that's it. Fortunately, the entire setup of joint venture is very much tried and experimented with. Again, to drive my point, I believe that the measure of protection should be linked with the measure of contribution. Now, in our case, when we are a minority stakeholder, we have our own strategies. Now, we have an advanced understanding of what our interest is, of what we want to achieve, of what amount of stakeholding rights do we need. We start with a minimally calculated amount of stock that would make us feel secure within a company. And then we look around as we move forward.
There's a special topic for minorities which relates to inter-party transactions. Suren, what is this about, and how do you solve this in the joint venture agreement to ensure that the minority is not damaged by any such inter-party transactions, as we had already heard from Aman in his example?
I think the subject that you mentioned about the interested party transactions is the historic sort of reason why the concept of squeeze out was introduced to the Russian legislation, because pre sort of 90, I don't know, I don't remember the year, but it doesn't matter. Pre-introduction of squeeze out regulation, there were numerous situations where public companies or Russian joint stock companies were unable to simply find minority shareholders and to get across, for example, the interested party transaction, or sometimes there were green mailers who were buying small stakes and using this as a means to blackmail the majority shareholder, asking them for various sort of benefits, unjustified, and this was the reason when the concept of squeeze out was introduced into Russian legislation. So I think that's where the interested party transaction angle comes in.
Thanks a lot. Oksana will have to leave us in 5 minutes, so I would like to give her the opportunity to say a few last words to us.
Спасибо большое, Корнелия, но это не по правам миноритарных.
Thank you, Cornelia. I'm not going to speak about minority rights. There's still way to go. Suren has a very interesting presentation. Now, my point is that we have touched upon extremely interesting and sensitive issues of operating a joint venture. There are so many situations that have to be discussed that need a solution, like a deadlock situation, a protracted deadlock situation, preventing a deadlock situation. In practice, all of this implies that there's negotiations involved. You have to come to terms with the parties in a gridlock. The pointed issue is how is this escape agreement will be handled. I believe we have had a very instructive discussion. I very much like the fact that that we have so many lawyers and so many minds. I am convinced that this bespeaks of our creative ability. Lawyers are creative lot, and they are called upon to find solutions. Now, my expectation is that we will all benefit from each other's knowledge. Thank you.
For an exit of one of the partners. Есть другая немецкая словица, который ужасный конец лучше, чем ужасный конец.
A terrible end is better than endless spate of horror. Thank you, Cornelia. May I use this opportunity to thank you for the possibility to speak. I would like to make a couple of preliminary remarks. Indeed, the name of our subject matter is the death of a joint venture. Yet, this is a subject matter that would lead us eventually to finding a solution to extend the life of a venture rather than killing it. A story came to mind, a very old story. When I approach a bus stop and the bus is leaving, what should I do in this case? The same situation is a failing joint venture. Lawyers have to find a way out. The first transparency offers you an overview of major reasons for having those stipulations in a agreement. These articles would be included in an agreement very early on. This is something that a whole range of investors do, like investment funds. They always insist on this kind of provisions to be included in the first place. Naturally so, protecting their rights is their main concern. Now, the first reason is certainty or stability in the arrangement of partners. This provision could be seen as a relief or as a preventive measure. All partners expect some benefits to be had from a partnership. But on the other hand, there's always an eventuality of a loss. Next reason is protection of partners' investments. Provisions of exiting a joint venture is also a protection stipulation. This is also a provision that would be used to fixed income, to stop losses. It is it can hardly be expected for an investor to behave otherwise. The mechanism of exiting a joint venture is in fact a mechanism of saving oneself from a protracted deadlock situation or stopping losses. Escape stipulations or provisions would also be used to discipline partners into compliance with the norms of an agreement. When partners analyze and try to read ahead the behavior of each other, they would try to prevent that from happening. This creates in itself a motivation for proper behavior. This motivation, in turn, would enhance benefits to be had by both partners.
Well, every time we review those exit issues, we need to look into the context. And we've mentioned several times, you have to look into your partners. Who are they? What are their perspectives of your partnership? What can you get from it? If you can include your analysis, if you have a chance to prepare the better exit provisions you can achieve. For example, whether your client is selling or buying, or the party that you represent, or here I would like to note that whether your partner is selling or buying in a major deal does not mean that this party is a seller or a buyer in the exit situation. You need to understand that sometimes parties enter very complex commercial agreements, like corporate agreements. They have a certain strategy, they follow a certain strategy which might not reflect their position in the major deal that you're actually structuring. Majority versus minority, once you're structuring your provision, you should see how these parties can influence corporate decisions and take care of minorities' interests, trying to get a chance to, for example, approve of the business plan and have the right to information. Parties should take into consideration who would be more sensible, business sensible, who knows the industry better, who controls the management, who would appoint CFOs. Finally, you need to understand who has a better access to financing. It could be their own equity or loan, and it also becomes very important in this context.
Natural buyer in a scenario where you have a foreign investor, both strategic, a foreign investor and a local Russian partner?
I don't think so. It depends on the circumstances. Not for me. There shouldn't be a natural buyer. There's so many scenarios. I mean, I think it doesn't come natural to me. So on this slide we are discussing Извините, я переключился на английский.
Sorry, I switched into English. And on this slide, we're looking into major events that lead to initiating exiting provisions. It could be change in circumstances when regulation changes or market changes, or a situation with an actual partner, or often it would be all sorts of circumstances. The second point is this deadlock, or dead-end situation we've been talking about. And if it doesn't lead to arbitration directly, the next step would be exiting provision, if you have them in your agreement. Default. We have heard about the case, and partners would often use default as a prompt or impetus to start exiting procedure. It can be, well, not every default leads to a major problems. The fourth point is change of control, and it could be a precondition for exiting. You may provide in the agreement the change of control to be the reason for exiting, but to ensure stable agreement, partnership agreement, you need to structure your documents to prevent change of control over a partner, I mean selling of a company of a higher level. Next, I would like to point out certain provisions that you, I mean, shareholders agreements or corporate agreements that you often meet in reality. I haven't mentioned several provisions, and I just wanted to voice them over. They're pretty simple. I mean, a lockup provisions. When the partners agree that over a certain period, initial period, they will hand over the packages they hold. It's a very simple provision. We're not discussing it. And the second one is priority rights in various fields, like a right of first refusal, right of first offer, various priority rights that Russian joint stock companies would have. Consequently, these provisions, these lockup provisions and priority rights provisions should be harmonized with the exiting provisions, the 4 exiting provisions that I have listed in the first place. The most typical objective for non-public companies is IPO, is a chance to start IPO. You can have different formula for that in your agreement. You may see very detailed. You may find very detailed provisions, including an underwriter selection provisions and choosing the package, regulating expenses and costs, and regulating income. Our next point is resale or strategic sale. When you're selling to a strategic investor, it may be just a declaration with no actual strategic investor in mind, but it might be a very detailed provision when the parties try to give a very detailed description of who can be considered to be a strategic investor, what would be the selling parameters, profits from the deal, etc., etc. And it's a very common exit mechanism, various options. I would include Russian roulette and Texan shootout. They're not exactly options, but there's a big number of various ways for the parties to decide who's buying out whom. And in a classical Russian roulette, you have one partner offering the other partner a deal to buy or sell his package, and the second party chooses whether they want to be a buyer or a seller. In the Texan shootout scenario, we're talking about how the price is being decided upon. Parties would sell each other offers, but normally the parties would have either put or call option. They either have a right to buy out or a put option. When they with the put option, they can demand to be bought out, and vice versa with the call option. They prove to be the most efficient options, and usually help to resolve the exiting procedure successfully. Tag-along and drag-along rights come next. This tag-along right is something you often come across. This right is all the minority shareholders with a small package are normally positive about this right. It's a right, you may entertain it or not. As for the drag-along right, usually it is the majority shareholder who has it, and there are a lot of disputes about limitations of the price, and because minority shareholder usually is bound to sell his package to someone who demands this drag-along right. From here we can get to valuation. We have already spoken about information, and I mean, finding the best price is a cornerstone. Normally, this valuation is is detailed in an agreement, and such provisions would normally be rather long. There are a lot of methods of valuation, and for various exits, they would differ. Various types of exits, they would differ. Here you have some direct valuation methods. The first type of valuation is determined by parties. You can combine it with the Russian roulette. When one party offers whether to buy or to sell, and the other party defines the price. Once it is provided for by the agreement, the second one, I mean fixed valuation. Normally, all parties think that the company should worth more, should be worth more. Calculating net profits, revenues, BDAs, you get it all with multipliers. And the last one is a fair market value, when you have someone who would provide this valuation. It's not necessarily someone who has a license for valuation. We may talk about auditors or bookkeepers or a company that would carry out this valuation. Normally, the process itself, valuation process, is set up in accordance with the agreement of the parties, because you have, I mean, all these documents, you need them when parties cannot find a compromise. A second process is when valuation is calculated by one party or by a joint venture CFO, someone both parties trust. Sometimes valuation is done by auditors or by investment bankers. As for valuation by investment bankers and auditors would normally use dry figures, and they would be more conservative in their valuation, while investment banks would use other criteria, synergy effect, and their valuation may be higher, and you'd often see minority and majority shareholders disputing over whom to use as valuator. And I would also like to talk about the broader context of exiting. First, changes in the agreements. Once you start exiting, the shareholders' packages might change, and certain provisions, certain clauses may not be applied. Sometimes you should probably cut modifications to the agreement. And long-term relations probably should be kept alive even after you exit the partnership. As for regulatory requirements, they should also be taken into account if we, for example, ruin right to foreign ownership or strategic relations with strategic partners. And I would also like to draw your attention to the mechanics. They test, all these exiting provisions, they test the legal technique. Sometimes you don't know whom you should notify, or you lack a date, or there's no one to make decision. You need to have it all properly set down in the agreement, because you might have problems with fulfilling those provisions. And I would also point out to termination provisions, to transfer restrictions and change of control, and this is something I have already mentioned. And in the end, to summarize, I would probably list my conclusions. I still think that exiting provisions, they add stability to a joint venture. Some find it difficult to formulate detailed exiting provisions, but it's saying that it's difficult to forecast the future. Of course, life is less predictable than an agreement, but still detailed exiting provisions can set up certain rules of life for the partners for the future and help people, if not to have a successful exiting, but provide a basis for future agreements or for a new deal. This is how you fix your place at the table for the future negotiations. Since we're looking at joint ventures in a general context, with no regard to Russian system, we have guests from Kazakhstan, for example. I would like to elaborate on the reform of the civil code. On Monday, by Monday, as for our current situation, all those mechanisms on alternative liabilities and option agreement, they should structure all those complex contractual mechanisms in compliance with the Russian legislation. Don't forget about the context. Remember whom are you representing. So exiting can be a very interesting situation. Cornelia asked me to give case examples. I'm not ready to do that, but very often you have a situation when you have very simple mechanisms. Even with priority rights, you can have a situation when somebody would buy out someone else. Thank you.
Of time, I would shift the discussion of whether shootout clauses and Russian roulette clauses are really reasonable to the gala dinner, and would now proceed with the premium discipline of joint ventures, which is, in my view, the 50-50 joint venture. And I would like to directly hand over to Elisaveta.
Добрый день, дорогие коллеги. Мне досталась самая неблагодарная роль, по-моему.
Good afternoon, ladies and gentlemen. I have to play an unpleasant role. I'm the only one between you and the gala dinner. So the issue is 50 by 50, and Svetlana has compared the joint ventures with families, and all people that get married plan to live for a long time and die on the same day. And there are not that many families with that kind of fate, and similarly, there are not that many joint ventures that live long and happy in the proportion 50 by 50. However, this ratio is quite popular. They are being set up. It means that they are in demand. Why so? The reasons why are the basic interest, the fundamental basis interest is economical. We have one group of enterprises where the strategic partners understand pretty well what the other party is, and in this case it is easy to sort out all the frameworks, or it is the joint ventures that are set up by two equitable partners who have a joint interest to implement some additional projects that have got nothing to do with their core business. As an example, I can give you an example of Megaphone and Wimpelcom, who are competitors at the mobile communications, but still they have a Euroset company, and the share of Wimpelcom and Megaphone is 50/50. What are the advantages of 50/50 joint venture? One is the availability of negative control, since neither party can have a control, but both parties have equitable access to information and the possibility to block decisions which did not suit the party for whatever reason. Another reason why setting up 50/50 is not to consolidate business in their accounting reports. It is important for a large company. My example, if your joint venture is in the non-core business area, you wouldn't like to have it among your indicators. And we're in the sanctions period, in the Ukraine sanctions period, the 50/50 subjects have received an additional impetus, and the 50% subsidiary of the equity under sanctions, if in the US it applies, and if there is no direct control, then that kind of joint venture is not under European sanctions, and so you can set joint ventures with that kind of companies that are under sanctions and feel fine. There are many reasons, and the classical structure is just like that when your joint venture is incorporated beyond the Russian Federation jurisdictions for obvious reasons that have been raised over here. Normally it is an offshore company in different jurisdictions, and SHA covers all the required frameworks. I will not talk about the principles of corporate governance, because Oksana has covered it at length. All the required committees are established. Alexei has talked about the financial frameworks, and all the Russian subsidiaries' decisions are linked to the decisions of the shareholders, even if it's formally the decision of a single shareholder or single partner. And at that, the real shareholders, the shareholders in the offshore jurisdiction, can control the operations. The question: could the 50/50 joint venture be a success, provided each of the party can block or cause problems? Of course, it could be a success, otherwise they wouldn't be set up. It is necessary to understand the objectives, the goals of setting up a 50/50 structure. I had an experience of dealing with such structures, but I haven't been setting them up, but I've been living with them, and then I was saying farewell to them. I do have a positive experience, but once again, it is important to understand the goals of the ambitions of such a company. You have to know what are your expectations. You have to understand long-term and mid-term prospects of such a company and how you will be withdrawing from it, exiting from it. And in case of Svetlana, her case is 49/51, but it shows that it is not always that those vehicles work, no matter how minutely we described all the provisions, all the clauses, and they sometimes they fail, and a large group of them cease to exist. I will skip certain things that I've been planning to say, not to bore, please bear with me. So why such joint ventures do not live for longer than 3-5 years? It is for mid-term only, and then the parties either should set new goals or transform the business somehow, or exit from the business. And one of the major reasons is that 50% partner tries to start the tug of war to control the things that initially the other partner should not control. And it doesn't mean it should be done in the operational context, and it is important to achieve the required synergy. And too bad if there's no synergy, and of course the parties have their own financial interests. I have a case from telecom industry. It was private and public partnership. The business looked very lucrative. The private company had an access to resources which were not used up to the hilt, and the private company approached the public company to run business more efficiency and to use the resources of the public company to provide services. The joint venture was set up, but the expectations of the two parties were different. That's why it was a short living, different business culture, and the public company had their different business culture. The regulations they could not violate, even though there were preliminary agreements on how to live, and as a result the private company just sold their share to the public company. That's the usual thing. So partners should not plan ahead for longer than 3 or 5 years, and for the very reasons that my colleagues, the other speakers, mentioned over here. It is important to describe many frameworks before the operations, but you cannot calculate or foresee the financial indicators, and the budget. And besides, 5 years after, different people might be working in the company, and 50/50 is just an alliance of two hearts that should be looking at the same directions, and as soon as they look in the opposite direction, the alliance, the union, is broken. Could it be successful? I think now there are many recipes that have been provided, and the recipes have been provided by the people that have an experience of dealing with such organizations on how to make your enterprise a success. Setting right goals is one of the recipes, and quite possible, and that's the case of our alliance. If there are two equitable partners, it is advisable to hire highly competitive management and to delegate authority, and think about remuneration, providing options, phantom or real, and the management should add value, develop value, and develop your enterprise. And in this situation, you wouldn't be then overstepping your responsibilities and trying to get more control than you are entitled to. And it is very important to have the right strategy. These strategies are studied and described, the options and those drag along, and the roulettes of different types, tag, dry along. I don't like the Russian roulette in the contracts, because there were 2 cases in my life when they were applied, and it was a sad story. It was the situation when one party, after losing trust, could use the weaknesses of the other party, or to choose the moment, and you are dependent on the good faith of your partners, and it is no good. So I would consider the deadlock frameworks, and it should be described in the contracts, in the agreements, in the shareholders agreement. But it is the framework is just one of the machinery to make you negotiate, and in case of 50-by-50, it results in withdrawal, exit of one of the partners, and in my situation it ended with the sales of the shares, and it might not be the appropriate moment, not when you are ready to exit, but when the circumstances prevail. And I made it brief, trying to be short. And I would like to get back to the structure and share my comments. There are stories that we have faced in real life. Such a structure, when all the decisions are taken at the top, might produce a lot of paperwork, red tape, and it can make the decision-taking process long. That's what Alexei mentioned, and if there is no comprehension at the top, it is fraught with risks for the company. The operations of the company may be paralyzed, and 2 ways out. One way out is to think over preliminary what are the things that you want to control and regulate, and what issues could be delegated to the management. And second way out, and the SHA should be handbook, guidelines for everybody that one should adhere to, because fine legal work does not mean that it could be implemented in practice. And something that I would like to emphasize, and that was mentioned by my colleagues, the changes into the civil code provide all the machinery, all the tools for us. And I visited the session dedicated to the civil code, and I was concerned. We have been mentioning at different deliberations that the market is short, have a shortage of the instruments, and there is a controversy even among the authors of the amendments into the civil code of how the enforcement will be arranged. And the courts interpret those things by letter, not in the spirit of the documents, and borrowing things from the other codes of the foreign jurisdictions might not be the proper approach, but we will be trying to refine the situation, and I just wish all of you to establish joint ventures, understanding what is the goal of such a venture, and then it won't fail, it will be a success. And I wish you have a nice time in the evening.
Personal recipe of how a partnership could work, and for this purpose I would like to make a round call and start with Svetlana, and would like to ask her to tell us how her recipe is of how a partnership can work.
Я считаю, очень важно в самом начале действительно.
I think in the beginning it is important to choose a partner. you should see the track record of interoperability of the partner with the other partners, analyzing situation and coming to terms onshore before you sail off. Thanks.
Сказала, надо очень хорошо.
You have to understand what you are doing for and do the groundwork well, making use the experience of the legal counsel and your own expertise to prepare all the documents well.
Is there anything to add, Aman?
Честно говоря, Светлана сказала.
Svetlana stated what I plan to say, and I think that when the joint venture is incorporated, you have to select the partner correctly, and it is not going for figures and not for who will be giving you the fairy tales of what the future would be. You should target the right people, the right team, and analyze the background of the partner to set up a stable vehicle for the operations for the near future. Thanks. And what's the recommendation, Surian?
Okay. No,
I can just tell a joke on the partnership, and if we are talking about the recipe, then it is important when structuring the deals. You have to understand, do you really need a joint venture? Sometimes it is necessary, but if it is 50 by 50 public transaction that occur, that take place, then we should understand that if it is 50 by 50 deal, you might find yourself in the situation when somebody will buy you off at a low price, or you will have to pay high for something, finance some company that you don't actually need. For partnership to work, first you have to think whether you need it at all, and could you possibly do without it, because joint ventures is not the best option to preserve your capital, and joint ventures result in the situation that money is lost. And well, I want to strike a positive note. It is necessary to understand the role of the partners and to understand the contributions of the partners, what is the input, and it is the clearly structured documentation, and of course one should focus on the rights that one can get from the joint venture.
Я добавлю, что стороны должны быть предельно.
And the partners should be transparent and open in any transactions, but of course it should be done when joint ventures are set up. Financial pictures should be comprehensible, and it is necessary to understand what is to be done, and you should tread carefully with 50 by 50 joint ventures. And all people are different, and we have to be aware about it, and there will be a time when the partners will understand that whose contributions are better, like the efforts, somebody's efforts might be more, so that it is important to evaluate the contributions of all the parties and structure the deal not 50 by 50 but at least 51 by 49, understanding that one of the partners will have a premium for day-to-day control supervision, for higher input. Thanks for your contribution.
Attention at this very late afternoon on a Friday. So, as I suggested, we can proceed with the topic at the gala dinner, or maybe we find other topics as well. So I hope you've had a nice conference and you've had some takeaways also from this session, and I look forward to seeing you again next year.